morning. I apologize for the delay. We've been working. I am going to hand each of you a copy of the jury instructions that you can follow along with me as I'm reading them to you. You will keep those with you, and you may use those to take back to the jury room with you when you begin working, but there will be an original of the court's charge that you will have to use for the official work that you do. So if you are working on something and it is stamped copy, that's not the original. All right? Members of the jury, in any jury trial, there are in effect two judges. I am one of the judges, the other is the jury. It is my duty to preside over the trial and to decide what evidence is proper for your consideration. It is also my duty at the end of the trial to explain to you the rules of law that you must follow and apply in arriving at your verdict. First, I will give you some general instructions that apply in every case. Then I will give you some specific rules of law about this particular case. And finally, I will explain to you the procedures you should follow in your deliberation. General instructions. You as jurors are judges of the facts, but in determining what actually happened, that is, in reaching your decision as to the facts, it is your sworn duty to follow all of the rules of law as I explain them to you. You have no right to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any rule I may state to you. You must not substitute or follow your own notion or opinion as to what the law is or ought to be. It is your duty to apply the law as I explain it to you, regardless of the consequences. It is also your duty to base your verdict solely upon the evidence that has been presented to you in court. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. As you determine the facts, you must consider only the evidence presented during the trial, including the sworn testimony of the witnesses and the exhibits. Remember that any statements, objections, or arguments made by the lawyers are not evidence. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. Also, do not assume from anything I may have done or said during the trial that I have any opinion concerning any of the issues in this case. Except for the instructions to you on the law, you should disregard anything I may have said during the trial in arriving at your own findings as to the facts. In answering the issues submitted to you, you must not be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feelings. While you should consider only the evidence, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts which have been established by the evidence. You are to decide whether the state has proved beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant is not on trial for any act or conduct not alleged in the indictment. Alleged offense. Now, bearing in mind these general instructions, the defendant, Aaron York Dean, stands charged by indictment with the offense of murder, alleged to have been committed on or about the 12th day of October 2019 in Tarrant County, Texas. To this charge, the defendant has pleaded not guilty. Applicable law and definitions. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Individual means a human being is who is alive. Deadly weapon means a firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use.